side are you arguing?
We're the petitioner.
Petitioner. That's the defendant, right?
Yeah. Which of the three arguments, or how many?
So I'll be addressing the first and third question, and my co-counsel will be addressing the second question.
Okay. So tell me which ones those
are. So I'll be addressing the local inapplicability and the violation of the ICCPR.
All right.
Proceed.
Mr. Chief Justice, Your Honors, good evening. May it please the Court. My name is Eleanor Myrie, and I'm joined by my co-counsel, Karen O'Neill-Ocasio. The first issue is whether the United States can enforce a federal statute in Puerto Rico, even when Congress has not expressed the intent to do so. And second, even if such an intent was expressed, whether or not that statute violates the International Covenant for Civil and Political Rights. The answer to both of those questions is a resounding no. First, the Federal Death Penalty Act does not apply to Puerto Rico because Congress has not expressed the intent for it to do so.
But what about the argument that all federal statutes are applicable to Puerto Rico unless Congress says it's not?
I'm sorry, can you rephrase the question, Your Honor? I'm not sure I understand.
What about the argument that Congress intended for all federal criminal statutes, code, to be applicable to Puerto Rico unless it accepts Puerto Rico from the statute?
Okay, Your Honor, in the I believe you're referencing the Puerto Rican Federal Relations Act, which the explicit language there says that it will be the statute will apply unless it's locally inapplicable. It's our position that the reason why Congress included that.
Who determines what is locally inapplicable?
Okay, Your Honor, in the First Circuit, Rivera-Torres, not Rivera-Torres, I'm sorry, in Cordova v. Chase Manhattan, then Judge Breyer. So, for the purposes of applying the Federal Death Penalty Act, we feel that the special relationship that Puerto Rico shares with the United States makes this locally inapplicable. There's a policy. There are two important reasons why this should not be applied here. First, there's a strong countervailing policy inference in Puerto Rico's constitution that suggests that Puerto Rico should not have to follow this statute. This court has held that when interpreting what's locally inapplicable, then we have to apply a textual analysis and look at Congress's intent. Nowhere in the Federal Death Penalty Act does Congress say that it wants to apply it to Puerto Rico.
But what about the applicable statute that imposes the death penalty? Does that apply to Puerto Rico?
Yes, Your Honor.
So you said the statute that opposes death sentence federal death sentence on Puerto Rico and Puerto Ricans cannot be executed.
Your Honor, and my colleague is going to talk. I'm sorry. That is not my argument. Our position is that even if a federal statute is constitutional, it does not make the execution of that statute constitutional. That is precisely why we have a due process protection in the Constitution, and my colleague will be addressing those due process concerns. And so although the federal statute imposes the death penalty, the special relationship between the United States and Puerto Rico precludes the application of that statute. Now, Puerto Rico's Constitution was also ratified by Congress. It was the understanding of the people of Puerto Rico that when Congress made ratifications to its Constitution, but did not amend the death penalty portion of that Constitution, that they were now joining the United States with that death penalty prohibition intact.
Well, that meant that the death penalty prohibition is intact within the Puerto Rican government and territory in itself. But the federal, they didn't say that the federal penalties shouldn't apply to Puerto Rico. They just said the Puerto Rican government itself will not enact any death penalty statute.
That's correct, Your Honor. But we believe that the national import of the death penalty sentence, as the respondent has claimed,
national to which national? Puerto Rican national.
47, Congress said that they would interpret silence in a statute to give Puerto Rico some leeway in legislating those affairs. And so it was the understanding of Congress when the Constitution was ratified.
But how does that line up with the default language in the statute?
And I believe you're referencing that the federal statute should apply if there's if the intent is unclear, correct? Your Honor, the rule that we propose that this court adopt is that when the statute is silent.
You want us to make our rule as opposed to the Congress's rule?
No, Your Honor. Congress has not been clear, and that's the matter that's before us today. The Congress has not been clear on whether or not they want the Federal Death Penalty Act to apply to Puerto Rico. Additionally, there's a strong countervailing policy reason why it should not. Puerto Rico made it very clear that they do not want the death penalty to be executed within their territory, and Congress has been silent on whether or not that should apply. And so we believe that taken together, this court should strike down that application. But even if we assume that the intent is there, and even if we assume that this should be applied, this also violates the International Covenant for Civil and Political Rights. That treaty was ratified by the United States in 1992. And Article 6 of that treaty says that everyone has a right to individual life. The FDPA is in clear contravention of that article.
But didn't the United States didn't sign on the total package? I thought it existed the death portion of it.
That is correct, Your Honor. The United States has attempted to carve out exceptions.
But I thought it did.
It did, Your Honor. It did, Your Honor. But if you look at the language that was used when it was signed, and when the Senate came before, when the U.S. government came before the Senate during the ratification, the government itself said that this was meant to impose certain restrictions locally. Now, if there are constitutional violations, that is, of course, not what we're asking the court to uphold. But the ICCPR has given standing, a district court in this great state of Florida gave a defendant standing under the ICCPR for the same article violation that is before the court today. So we believe that in the ratification of this treaty, that the United States...
Are you referring to the juvenile...
this is the...
Given that circumstance, and given the fact that Puerto Rico as a community is a distinguished, marginalized group when it comes to lawmaking, it immediately triggers a substantive due process issue under the 14th Amendment. The 14th Amendment says that the government cannot deprive a person of life without due process. And this is a cornerstone of our democratic process in the sense that... So
you're saying Mr. Pujols wouldn't have due process under the 14th Amendment?
He should, but in this case he's not.
Will not? Why so?
There are a couple of reasons. First, the right to life is a fundamental right. We've identified
That's a fundamental right for every American citizen.
Yes, Your Honor. From the Declaration of Independence, we've seen life as an inalienable right, and that's also been translated into the 14th Amendment. And it's not the question of whether a person's life can be taken away. It's the question of whether there's a process in that. And we believe that in this case there isn't, for several reasons. On one hand, you have the fundamental right issue, but on the other hand, you have the fact that Puerto Rican community is marginalized, both from the executive, judicial, and legislative branch of the federal government. On one hand...
Isn't that a political question?
No, Your Honor. It is a legal question because it deals with the legitimacy of applying that law to a community of U.S. citizens. And in that legitimacy is the question of consent. And to continue with that, from a legislative perspective, there's 3.6 million U.S. citizens who are not fully and effectively represented in the lawmaking process and who weren't fully represented when the FDPA was passed.
That includes the citizens of Washington, D.C.?
Your Honor, it's possible, but in this case, our client is from Puerto Rico.
Oh, yeah, okay.
Along those lines, for instance, the only representation that these 3.6 million people have in the legislative process is a resident commissioner that has no voice or vote in the process. Second, when it comes to the executive branch, when we come to sign the FDPA, again, Puerto Ricans do not have the right to vote for the president. So there, in terms of having a heightened level of reliability on the process.
So why should any federal law apply to Puerto Rico then, in that case?
Your Honor, in this case, we're specifically focused on the substantive due process issue concerned with Puerto Rico because it has to do with the right to life. Basically, if we're allowed to apply the FDPA in Puerto Rico, we're saying that millions of citizens are potentially subjected to expressly stated that the death penalty would not exist within Puerto Rico. Furthermore, this is a question of whether millions of people could potentially be subjected to execution without any type of voice or representation in the law that is meant to authorize this. And as a cornerstone of the American legal system is the idea of consent. And in this case, in either stage, from the creation of the law to its enactment, and even within the jury itself, there is no representative and effective voice for the Puerto Rican people. So for example, at the jury level, for a federal court system, people need to speak English and be able to follow the legalese of the court. Only 25% of the people in Puerto Rico are allowed to do so. Your Honor, I see that I've run out of time. May I finish my thought?
Wrap it up, one sentence.
And basically, the fact that there isn't effective representation in the jury of the peers of, for instance, our client, Mr. Picot, shows that there is a clear reason for why the FDPA should not be applied in Puerto Rico. Thank you.
Thank you.
Thank you.
You may proceed. Please proceed.
Good afternoon. My name is Lynn Vasquez, and on behalf of the Respondent, I will be addressing the issue of whether the Federal Death Penalty Act should apply to the residents of the Commonwealth of Puerto Rico. The Federal Death Penalty Act should apply to all United States citizens, including those residing in the Commonwealth of Puerto Rico, for the following. First, Congress intended for the Federal Death Penalty Act to apply to the Commonwealth of Puerto Rico as punishment for the violation of federal crime. Second, there is no substantive due process violation by the application of federal law to the Commonwealth. And third, the ICCPR, a non-self-executing treaty, itself states that there is an allowance of the punishment of death for only the most serious crimes, just as is the case in this scenario. Your Honors, in light of the foregoing, the Respondent respectfully urges this Court to affirm the holding of the First Circuit and find that the Federal Death Penalty Act does apply to the residents of Puerto Rico, including Petitioner. To my first point, concerning the application of the Federal Death Penalty Act as punishment of federal crimes. First and foremost, Your Honors, the Puerto Rican Federal Relation Act creates a general rule that applies all federal laws to the Commonwealth of Puerto Rico. There is an exception in the language of this provision that states that those which are locally inapplicable will not apply. However, of the United States Code, specifically in the underlying action, we have reference to the two crimes committed by the which are Title 18, Sections 924 and Sections 1513. Both of these provisions, 924 specifically, is extended to the Commonwealth of Puerto Rico in its statutory language. Furthermore, Section 1513 includes extraterritorial reach. These substantive portions, as provisions of the Federal Criminal Code, do directly apply to the residents of Puerto Rico as United States citizens. Furthermore, it is the Federal Death Penalty Act which applies broadly as punishment for these only most heinous crimes. There is, in fact, no locality designation in that Federal Death Penalty Act.
And you think that there is no import to the fact that Puerto Ricans have not had a voice in those decisions by Congress?
Your Honor, that speaks to the third issue raised by Petitioner concerning the lack of representation and the substantive due process violations. Specifically, there must be a designation for substantive due process violation of a fundamental right. While that does invoke certain constitutional protections, the lack of a representative in Congress with full voting power, this is not something that falls under the purview of substantive due process. Rather, the argument to be made may be one of equal protection, that there is a marginalized class here. However, as required by this court in Cornell of the United States, if it is not a racial class or a national origin class, again, United States citizens are those who reside in Puerto Rico that are being considered in this case. Therefore, any unequal application of law is not done based on race or nationality because we are all United States citizens.
So you think whether a particular people had a voice in the enactment of the law, that is of no import?
No, Your Honor. There is an important recognition to be made of the fact that there is a differing level of voice. However, this is not due to the mandate of law from the federal government simply limiting the amount of expression for the people of Puerto Rico. But rather,
so if tomorrow Congress decides to issue a law making the income tax laws applicable to the residents of Puerto Rico, no, they have not had a say in Congress for Congress to do that. Would that be okay?
Your Honor, that would be dependent upon, again, the understanding of the Federal Relations Act, the Puerto Rican Federal Relations Act.
Based on the federal, on the resident commissioners with 0 votes, so they have increased the presence in the Congress with 0 vote. You realize that if Puerto Rico were to be a state, probably have more representatives in Congress than about 23 of the United States. In other words, Puerto Rico will be one of the biggest voting blocks in the United States Congress.
Yes, Your Honor.
So then at that time, then you can extend income tax to Puerto Rico because now you have a bigger voice than about 23 of the other states.
That is precisely correct, Your Honor. If there was a completion of the statehood process, then that would immediately invoke the Article 2 provisions, which would require full representation, as well as mentioned by petitioners, a right to vote for president and so on and so forth. However, the same would go if there was an increase of taxation. This would necessarily require an equal representation for the people of Puerto Rico. However, until those circumstances arise, there is no need for a strict scrutiny analysis for that deprivation. Furthermore, Your Honors, this returns me to the fact that several applications of law have been considered. In the First Circuit, the U.S. v. Quinones v. United States in 1985, the court specifically applied a scenario which is much similar to the petitioners in that the Omnibus Crime Act, which extended wiretapping availability, applied.
But you've heard the argument against that in that wiretap, even though it was not explicitly applicable to Puerto Rico, and even though there was a constitutional prohibition in the Puerto Rican Constitution, wiretapping, which was really an evidentiary issue as to whether or not the wiretaps could be introduced in evidence, the argument is that it does not equate to the deprivation of life. And so therefore it's easier to make that decision as opposed to one so, what I call a fundamental right, i.e. the right to live.
Your Honor, the government respectfully disagrees with that viewpoint, that there is a requirement to give a heightened scrutiny solely because of the outcome of an extension of law to the federal residents in Puerto Rico. There are 2 different analyses that must be made by this court. The first concerns the extension of federal law, regardless of the outcome, regardless of what the circumstances are. If that application is extended, then what arises is a substantive due process issue, if there is in fact a deprivation of life. To merge the issues confounds the problems for this court and presented to this court. And for that reason, they should be separated. No specific application or exception for the Federal Death Penalty Act. However, again, it is for this court to look to the congressional intent, which the government argues is present in the application of federal crimes. Congress's purpose in extending those federal crimes is the same that goes for any citizen of the United States in any state, and that is to protect from the most heinous crimes. The procedural aspect of the federal death penalty merely follows as punishment. The petitioner argues that there is, for some reason, some due process issue which has risen from that. However, what's important to remember is that the procedural due process guarantees of the Fifth Amendment of the Constitution, which apply to the federal government, in fact, do extend those protections to the people of Puerto Rico. It is not a mandate that all Puerto Rican residents may be killed, but rather that there is a prosecutor.
Yeah, but we cannot overlook or take lightly the fact that in all these laws that are being passed, the people that have been affected by those laws have not had the opportunity to say something with respect to those laws. And I think that's what the focus is when they're talking about violation of substantive due process.
That is correct, Your Honor. There is a suggestion by the petitioner that there is a recognition of the lack of representation. However, under this court's analysis, that representation must be considered not as something that is fundamental, because Article 2 of the Constitution grants the process and the option to participate in the political process to residents of the states. That is specifically the constraint put on this court by the Constitution. So without statehood, there cannot be full representation in Congress.
So they're still second-class citizens, basically.
No, Your Honor. They have a different locality, which is a determination of how the status interacts.
Which determines the status as second-class citizens because of their inability to vote.
Your Honor, I respectfully disagree with the statement that they are.
You don't have to even respectfully disagree. You can just disagree.
Respectfully nonetheless, Your Honor. I respectfully disagree that there is, in fact, not a second-class status, but a different class status. It is important to note that what is the same...
They're separate but equal, in other words.
No, Your Honor. They are not separate but equal. They are merely different because there is clearly a difference in the unique relationship between the two localities. What is important to remember, though, is in their representation as United States citizens, residents of Puerto Rico are entitled to the same voice and application of law that any of the several states would have. And I realize, as the court has mentioned, that there is a difference with this representation. However, the representation is something that is a different analysis because of their status as a commonwealth. This Commonwealth, again, Your Honors, was agreed to in a compact at the time of the creation of this Puerto Rican Federal Relations Act. It's really important before this court as something that protects all United States citizens.
There's no arbitrary deprivation, just deprivation nevertheless.
Yes, Your Honor. However, if I may briefly conclude, as I see my time has expired, the analysis, may I briefly conclude, Your Honor?
You may.
Thank you, Your Honors.
Briefly.
Yes.
One sentence.
In light of the fact that there is, in fact, an analysis to be applied to the court where it must consider the compelling governmental interest, the respondent respectfully urges the Federal Death Penalty Act should apply to residents of Puerto Rico as United States citizens. Thank you, Your Honors.
Thank you very much.
Thank you.